Hello everyone, my name is Rathir Samatpanyakang. I'm a junior law student of the American University of Phnom Penh. Today, I'm going to brief a case about Dillon vs. Legg. First, I'm going to talk about the fact of this case. Second, I'm going to talk about the issues of this case. Third, I'm going to talk about the holding of this case. Fourth, I'm going to talk about the reasoning of this case. And fifth, I'm going to talk about my personal observation about the reasoning of this case. So now let's talk about the facts of this case. While driving his automobiles, the defendant David Luther Legg negligently struck and killed Aaron Lee Dillon. When the accident happened, Dillon lawfully crossed a public street. Dillon's mother and sister witnessed the accident. Dillon's mother and sister, who are the plaintiff, sued the defendant for wrongful death. The plaintiff also sued the defendant for negligent infliction of emotional distress because they suffered severe mental and physical injury after witnessing the death of their close family member. In trial court, the court dismissed the mother's claim for emotional distress. The reasoning for this decision was that the mother was in close proximity to Dillon at the time of collision, when she was outside of the zone of danger. According to the zone of danger rules, a victim of negligent infliction of emotional distress must be in the zone of danger. Dillon's sister's action for emotional distress, however, was not dismissed because she was in the zone of danger and fear for her own safety. Therefore, Dillon's mother appealed. The issue present before this case is, can the defendant be liable for negligent infliction of emotional distress to the plaintiff when the plaintiff was not in the zone of danger? Please pause this video and try to answer this question using your moral and legal knowledge. Now, let's talk about the holding of this case. The Supreme Court of California held that the plaintiff can recover damages for negligent infliction of emotional distress from the defendant even if the plaintiff was not in the zone of danger. Now that we know about the holding of this case, let's talk about why the Supreme Court of California came to this conclusion. The trial court dismissed the mother's claim based on three main reasons. The first reason was that in regard of the zone of danger rules. The second reason was in regard of the fear of opening up for fraudulent claims. And the third reason was the indefinable claim of the mother action. So in response to the first issue, the Supreme Court of California addressed the issue by pointing out the hopeless artificiality of the zone of danger rules. The court stated that we can hardly justify relief to the sister for trauma which she suffered upon apprehension of the child's death, and yet deny it to the mother merely because of a happenstance that the sister was some few yards closer to the accident. The court reasoned that if this court denied the mother case based upon the zone of danger rules, this court indeed rejects the impact rule which is necessary to recover an injury. In this case, the mother was without a doubt suffered mentally and physically as the result of witnessing the death of her daughter. As this court stated, it is a matter of general knowledge that an attack of sudden fright or an exposure to imminent peril has produced in individuals a complete change in their nervous system and rendered one who was physically strong and vigorous weak and timid. Therefore, the zone of danger rules must collapse because the only reason for this requirement of plaintiff present in the zone lies in the fact that one within it will fear the danger of impact. Regarding the second issue, the Supreme Court of California argued that this court in the past rejected the argument that this court must deny recovery upon a legitimate claim because other fraudulent one may be urged. According to the case of Dillon versus Witt, the court stated that the contention that the rule permitting the maintenance of the action would be impractical to administer is but an argument that the court are incapable of performing their appointed tasks, a premise which has frequently been rejected. In the case of Owen versus Liverpool Corps, this court held a position that fear that unfounded claims may be put forward and may result in erroneous conclusions of facts ought not to influence as to impose legal limitation as to the nature of the facts that it is permissible to prove. Therefore, this court concluded that the possibility that fraudulent assertions may prompt recovery in isolated cases does not justify a wholesale rejection of the entire class of claims in which that potentiality arises. For the third issue, the court stated that a proper guideline can be indicate the extent of liability for such future cases. In determining whether the defendant owes the plaintiff a duty of care, the court will take into account three factors as the following. First, whether the plaintiff was located near the scenes of the accident. Second, whether the shock resulted from a direct emotional impact upon the plaintiff from the sensory and contemporaneous observation of the accident. Third, whether the plaintiff and the victim was closely related. Therefore, the court found that this case satisfied all of the three requirements. Now that we know about the reasoning why the Supreme Court of California reached this conclusion, I want to give my own personal observation. I agree with the decision of the Supreme Court of California that the decision is just for the matter. It would be unjust for the matter to not be able to claim injury from the defendant, who without a doubt inflicts emotional distress to the matter. I agree with the court that the purpose of having the plaintiff present in the zone of danger is to certify the plaintiff emotional distress inflicted from the defendant negligence. If, however, no argument was posed to question the mother's emotional and physical injury from witnessing the death of her daughter, the zone of danger rule should not apply because it contradicts the fundamental idea of having the zone of danger rules, which is to certify the injury of the impact. So thank you for watching this video. I hope you can learn something from this case. Thank you.